Comprehensive plans are all about community, and each of your cities has its own character, its own vision, its own direction. AWC developed a series of short videos to help you prepare your GMA update. Each video contains a few key concepts and conversation starters that you can relate to your community. This segment looks at minimizing legal risk.
What I'm going to do is basically go over the basic do's and don'ts to kind of prick your ears to issues that you need to be conscientious of, and maybe ask for advice from your city attorney or whatever on how to handle that particular situation. And the first do I'm going to address at this point is essentially embrace delegation of decision-making authority. As you go through your comprehensive plan updates and your development regulation updates, your insurance companies are in the wings, biting their nails, a little bit nervous that you're going to start looking at that chapter that deals with who, what makes what decision in the permitting process. And they have some fairly valid concerns there, so I'm going to take this opportunity to explain to you why that is a concern. Pretty much the worst thing that's going to happen to you if you make a bad decision with your comprehensive plan is that it'll get invalidated by the Growth Management Hearings Board. It's very rare. I've never heard of a situation where someone actually gets incurs monetary damages for making a bad decision when it comes to putting together a comprehensive plan. At the same time, the restrictions on the types of things you can put in your comprehensive plan, there just aren't a whole lot. You've got the Growth Management Act, but beyond that, it's essentially, what are your values for community and what do you want to do with it? That's a really broad-based decision-making process. And of course, you as elected representatives are the most suitable people to do that. And by state law, in fact, you have to make that final decision. Now, as you get into the development regulation level, things get a little more restrictive. You have to start worrying about constitutional principles like takings and due process. And if you deprive people of all their property rights, you can incur liability there for adopting those kind of regulations, at least as they're applied in a particular permit action. And again, state law requires you to make the final decision, so there's no question you're going to be involved in that. Okay, the next stage in the planning permit, that's where you start having issues, because there are all sorts of sources of liability. I mean, there's a state statute, RCW 6440, that provides that if you deny a permit application and you do so in a manner that's unlawful or doesn't comply with adopted deadlines, you'll owe damages to the property owner. And that statute only applies to the property owner. If you violate someone's constitutional rights, whether it be a due process, takings, First Amendment, freedom of expression, religion, you can owe damages there as well. There are appearance of fairness issues where if you look, like you're being biased, or you've engaged in communications outside of the hearing process, that can invalidate a decision, and arguably that's a matter of current argument. It could lead to damages as well. And finally, you have to make your permitting decisions, within deadlines that are set by the State Regulatory Reform Act, and those are short deadlines, like 120 days for most type of permit applications, from the time you file a complete application to the time that you issue a final decision. And while you have all these potential liability sources, at the same time, the discretion that you have in issuing a permit is really limited. The courts in this state are very strict about the fact that when you decide to tell someone they can't develop their property, it has to be based on something that's in your code. And that code provision has to be interpreted in a manner that applies to everyone else equally. So, if you've done a good job with your comprehensive plan and development regulations, you really don't have too much to worry about at the permitting stage, because if you delegate it to a hearing examiner, they're going to do what you want through those development regulations. And in fact, there's no choice to do anything else. So for all those reasons, that's why the insurance companies, tend to like it when you delegate to the hearing examiner. Now, there is some discretion at the hearing examiner level. Sometimes, there's going to be some ambiguity there, and you don't know quite which way to go. And the hearing examiner is then going to look at your comprehensive plan and try to figure out how you'd like that decision to be made. But ultimately, if decisions are coming out that don't appear to you to be what you intended in your development regulations, you have the authority as an elected official to change your regulations to address that circumstance. And believe me, that's happened to me as a hearing examiner, where I've come up and set up some precedents, and I'm not sure if that's the way the council wanted to go. And ultimately, the council decided to go a different direction and amended their code accordingly. And that's another reason why it's also a good idea to interact with your hearing examiner on a yearly basis. Have meetings with them to see if the decisions are going as planned pursuant to your development regulations, or they need amendment. So, Anyway, that's the first do is embrace that delegation. It's okay to delegate to the hearing examiner or somebody who's paid to do a good objective decision that keeps you out of the courts. All right, the second do, and this is of course very fundamental to the land use planning process, is do respect private property rights. In referring to private property rights, I'm essentially referring to the due process and takings clause. And there's a great quote coming out of a 1982 decision, Norco Construction versus King County, where the court said the basic rule in land use law is still that absent more, an individual should be able to utilize his land as he sees fit. In other words, don't be telling people what to do with their property unless you have a good public reason to do that. And where that comes, essentially, it's based upon, as I mentioned, the Fifth Amendment, which is where the due process and takings clause comes from. And on your screen, you'll see the actual text of that. We actually don't see that very often, so I'm going to read it to you so you see exactly, the source. Basically provides that no person shall be deprived of life, liberty, or property without due process of law. That's the due process clause. Nor shall private property be taken for public use without just compensation. That's the takings clause. Now, the takings clause, in terms of the insurance companies, that's the one that they're most concerned about because, you can't take property without just compensation. If you do that, the court's going to make you pay just compensation, and that can cost quite a bit. And, of course, the taking situation we're most familiar with is when property is condemned to build the freeway or to build a trail or something like that. But what's going to happen more often in the land use decision-making process is the regulatory takings, where the government doesn't actually appropriate somebody's property, but they lay on so many restrictions that there isn't much use of that property left. If you essentially, for example, require, impose buffers for wetlands that are so restrictive that someone can't do anything on a 2-acre piece of residentially zoned property, they may very well be able to claim that you've taken their property without just compensation. And actually, a lot of people are familiar with the regulatory takings doctrine, and I think they actually, the common belief is that it goes further than it does. I mean, the courts, and it's very difficult to come up with broad generalizations, but the courts generally, I mean, if you've got 10% of your property value left, if you're restricting that property for an important, valid public purpose, there's a good chance that'll hold up. You can go pretty far with your regulations before you start incurring that takings liability, but it can be there. One of the more pressing takings issue that's been happening in the last few years, and that's been a matter of some concern, is adopting development moratoria. All right, so a lot of communities, as they update their regulations, they may conclude, oh boy, we're going to be making some big changes to our critical area regulations. We want to make sure that people don't start filing applications right away in order to avoid those new regulations. So we'll adopt a moratorium on development in this part of the city or across the whole city. That can work for 6 months or maybe a year. But once you start getting past that year-long period, the courts actually will start imposing some takings liability. I mean, moratoria that go on for an unreasonable period of time can lead to takings liability. So keep that in mind if you want to go with the moratorium option. Now, the way to avoid takings liability in your code, one of the most important things you should do is you should have a good variance process for your zoning code and a good reasonable use exception process for your critical area regulations. And what those do essentially is that, when you adopt these regulations, you can't foresee exactly how they're all going to interrelate on every piece of property in your city. And there are going to be some circumstances where, even though you didn't intend it, when all these regulations are heaped on, the person can't do anything with their property. And of course, that's going to be a situation you're going to have a taking. So what the variance and the reasonable use exceptions do is they essentially allow a hearing examiner or whoever you've assigned that decision-making authority to waive the regulations to the extent necessary to avoid that takings. For the reasonable use provisions, I mean, a lot of the common reasonable use provisions actually specifically state, in order to avoid a due process or takings violation, the regulations can be waived to the extent necessary. The variance process, they don't mention takings usually directly. They come out of actually state law. They have their own criteria, but you want to make sure that that's in your code and that it works. The second part of private property rights, the second most important component, is the due process clause. And that's all about having reasonable regulation. It's all about reasonableness, where you essentially balance the public interest that's being protected by the regulation versus the burden that's placed on the property owner. And if that's out of whack and there's too much burden versus public benefit, the courts are going to invalidate the regulations. I mean, if you adopt a regulation that says that all the homes in your city are to be painted blue, you're probably not going to be able to come up with a good public purpose for that, and the courts are going to toss that out. One of the more important parts of this reasonableness component in due process is that you must adopt regulations that are clear and easy to understand so that they're applied equally to everybody. And there's a great quote from Anderson versus Issaquah that embodies what that's all about. It says, "An ordinance which requires the doing of an act in terms so vague that men and women of common intelligence must necessarily guess as to its meaning and differ as to its application violates the first essential of due process law." So keep that in mind, especially if you're dealing with really vague subjects like aesthetic design, design regulation. When you adopt standards that say you must have colors that are harmonious and interesting, that's the kind of language that's going to get you in trouble and have regulations thrown out. So make sure your standards are clear, and that everybody in the council understands what they mean, because then that probably means that people on the outside can understand what it means as well.